believe a representative of the people who confesses to have engaged in that conduct. I am inviting you to find the overall conduct of these people to be not worth of your credit. But let me point out something else. Mr. Peter Wanyama, advocate for the governor, says, in fact, he logged into this system twice and voted. The county assembly's expert has not seen that login of his. The governor's own expert today has confirmed he didn't see that login by Peter. The independent expert by this house has confirmed he didn't see that login by Peter Wanyama. It means the governor's case theory is found on a shameless lie that an advocate of the High Court of Kenya, and our profession, Mr. Speaker, sir, thankfully for me, you belong to this profession, and distinguished senators, some of you belong to this profession, abhors an advocate vouching for his client. An advocate presents evidence as presented by witnesses and the law established. But if the advocate himself can take the extreme stance taken by Mr. Peter Wanyama Learned Counsel to present a factual wrong that he logged in this system and voted, a fact which his own witness says, I didn't see it in the logs, a fact which the independent witness of this house, the expert, says, I didn't see that in the logs. A fact which Mr. Peter Wanyama himself was unwilling or unable to take the witness stand and be cross-examined on. I invite you to draw a conclusion that there is enough evidence that the governor was willing to go to any extent to deceive this house, that this voting process was in fact compromised. Let's face it, distinguished senators. Every system, ICT or otherwise, can be made better. Any system can be made better. Banks work on ICT system, and many other systems now, operations work on ICT systems, whether they medical systems, whether they aviation industry systems, and all other systems. Each one of them can be made better. The fact that the system adopted by the County Assembly of Kericho can be made better is not a basis for invalidating that which it has done. The only basis for invalidating that which it has done is credible and irrefutable evidence that the system was in fact compromised, not capable of being compromised. No single witness before you has brought that evidence that this system was in fact compromised. Learned Senior Counsel, Mr. Katwa Kigen, I would reiterate, Mr. Speaker, sir, one of the most courteous counsel that I know, one of the most polite counsel I know, and a mentor to many young lawyers that I teach, came here and this, in his opening remarks, which are captured at page 25 of Wednesday this week morning, observes that this site was pulled down, and in a response to the PO, it was brought up again. The logs by these witnesses would have shown that act of pulling down the site and re-uploading the site. Not the County Assembly's witness, not the governor's witness, not the independent witness of this Senate has captured that log of interference with this site by pulling it down and re-uploading it. I am reiterating a simple and straightforward case that this evidence shows that this governor could go to any extent, including getting senior and reputable counsel to present factual inaccuracies before this Senate just to achieve the termination of these proceedings on a technical objection. As you vote on this issue, I beseech you to debate these questions, and if you reach answers contrary to these submissions, I will leave with your verdict peacefully If you reach a verdict that conforms to this verdict, once again, I will be able to live with it peacefully. Look at how the county governor's council stood before the county assembly and the governor himself and commandeered, assumed the speaker's role, commandeered the MCAs stand up. What had they done to those MCAs to assume that kind of control over them? I am not sure that if I stood before here and commanded these senators to stand up in direction, they will take it seriously, however persuasive my case. What had they done to them? Between this system that provided some form of privacy for the individual MCA and the so-called roll call system, in that context of this governor and this advocate commandeering MCAs on record, which one would have guaranteed better integrity and independence of decision-making by this assembly? It is expected that any MCA who took advantage of that semblance of independence and voted for this motion, having been earlier intimidated and commandeered, may consider stating that they had not voted. In the next few minutes, let me reflect on the question raised by the majority leader on the 3 MCAs. For starters, distinguished senators, there were 4 who took that position as represented by the governor. Along the way, my learned colleague, Mr. Katwa Kigen, confirmed one of them abandoned that position. This position that we did not vote, which witnesses are liberally taking and abandoning, can we take it as a definitively confirmed position that witnesses didn't vote? Because they are taking and abandoning. That's number 1. Number 2, let's look at the residual 3 that are of concern to the question raised by the majority leader on behalf of the House. One of them is Martin Kiplangat Cheruyot. First, you'll notice that Martin Kiplangat Cheruyot swore the same affidavit with Edna Tonui. Same affidavit, they jointly signed it as we. Edna Tonui has now told us, I never signed that affidavit, by her own affidavit. On what basis would we believe that affidavit where one of the owners has disowned? It is said, Mr. Speaker, sir, distinguished senators, that if the alligator came from the sea, systems do this, an expert told to audit this system can recommend some things that can make this not to happen. It does not mean that what we are doing here is invalid. What we are doing here remains valid regardless of this kind of systemic challenges. So I'd said, it is said that if an alligator came from the sea and told you, Mr. Crocodile is sick, you don't say, I am going to the sea to verify for myself. In regard of the affidavit jointly sworn by Edna and Martin Kiplangat Cheruyot, the alligator that has come from the sea, symbolically speaking, and with due respect, is Edna. She has told us that affidavit is fake. That signature is not mine. How much more evidence do we need to discredit that affidavit? Then comes the other joint affidavit of the 18 MCAs, on which, again, Edna's name is indicated. She has come from the sea and told us that affidavit is fake. I didn't sign it. Why would we believe anything from that affidavit? So that would be the approach, Majority Leader, distinguished senators, if I were confronted with that evidentiary question. But that is not enough. That is not enough. Consider the evidence of Amos Birir Trump, who is asked a simple question, Mr. Speaker. This affidavit you claim to have signed jointly, the 18 of you, what time did you sign it? Daytime or nighttime? He says he signed it after lunch. It turns out the assembly proceedings went on until past 8 p.m., and that affidavit contains proceedings of the assembly, meaning it could only have been signed in the night. Normal advocates would have closed their offices at that time. They would tell their clients to come back tomorrow.